welcome to 5-Minute Family Law. Today, we're going to be talking about the nuts and bolts of parenting after separation. We'll get into this subject in a lot more detail in future episodes, but today we're just going to provide a general overview of the subject. When parents separate, they have a bunch of very difficult decisions to make about how they're going to continue parenting their children now that they no longer live in the same home. Under the Divorce Act, the legislation talks about these decisions in terms of parenting time and decision-making responsibilities. Parenting time is the schedule of the children's time between their parents' home. Decision-making responsibilities is about how the parents work together or don't to make important decisions about almost every aspect of the children's lives, from where they go to school, to how they're treated when they get sick, to choice of language instruction, religious instruction, things of that nature. The Family Law Act uses almost exactly the same language. It also talks about parenting time, but instead of decision-making responsibilities, it talks about parental responsibilities. But for our purposes, they mean almost exactly the same thing. Let's talk about parenting time in a little more detail. It's important to understand that in Canada, there are no legal presumptions about the parenting schedule that works best for children. The reality is that children's needs change depending on their age, their maturity, and their stage of development. As well, what works really well for one child may not work well for another child, even though they're in the same age and they have roughly the same circumstances. As well, the parenting schedule that works well for a child at a particular age won't work very well for that child only a few years later, as they're more mature, more independent, and they have different social needs. As a result, when you're talking with your ex about the children's parenting arrangements, it's important to be flexible, to be creative, and to remember that there aren't any presumptions that a particular division of time is the best division of time, or that the children are best off living with one parent because of that parent's gender. And now, let's talk in a little more detail about parental responsibilities under the Family Law Act or decision-making responsibilities under the Divorce Act. There is a presumption that both parents will be entitled to exercise all parental responsibilities. This means that in most cases, both parents are going to be required to talk to each other, to consult with each other, and to cooperate with each other when important decisions need to be made in a children's life, such as where do the children go to school? How do they get treated when they get sick? Now, the legislation also recognizes the possibility that parents may not be able to get along well enough to be able to cooperate with each other. As a result, it's also possible for the court to order or for parents to agree that one parent will be responsible for some parental responsibilities while another parent will be responsible for other parental responsibilities. So, for example, one parent might have the exclusive responsibility for making decisions about a child's education, while the other parent might have exclusive decision-making authority about a child's health care. There really are only two ways that issues about children's parenting arrangements get resolved. If the parents are able to cooperate and find compromise, they can sign a separation agreement that talks about the distribution of the children's time between their houses and about the agreement they've reached for how they'll make decisions on behalf of the children. If they can't cooperate or can't find compromise, on the other hand, they may have no choice except to take the issue to a judge or an arbitrator who doesn't know their children from a hole in the ground and ask them to make a decision about the children's parenting arrangements for them. However issues about children's parenting arrangements wind up getting resolved, it's important to know that under both the Divorce Act and the Family Law Act, the only thing parents and judges can take into consideration when making decisions about children are children's best interests. Both pieces of legislation contain long lists of the different factors that parents and judges can take into account when deciding the course of action that is or isn't in children's best interests. In the Divorce Act, you can find this list at Section 16. In the Family Law Act, it's at Section 37. This list is actually a really good thing to read because it's a helpful reminder of all the different factors and realities that are involved in raising a child. So, looking at the Divorce Act, for example, Section 16 includes as factors to consider the child's needs in light of the child's age and stage of development, the nature and strength of the child's relationship with each spouse's willingness to support the development of the child's relationship with the other spouse, the history of care of the child's views and preferences, as well as other factors such as each parent's plans for the future care of the child, the children's history of cultural, linguistic, and religious upbringing, and other factors including family violence. There are, of course, many other things we could talk about in terms of parenting after separation. But what I'd like to leave you with is the idea that the entitlements involved in parenting time and parental responsibilities under the Family Law Act and the Divorce Act aren't really so much a question of rights than they are of responsibilities. They are, at the end of the day, a collection of child-centered obligations to do your very best to responsibly care for your children even after your relationship with the other parent has broken down.